Hi, my name is Andrew Kinney. I'm an attorney at Hoagland Law Offices. I've been practicing in the area of Social Security Disability for over 20 years. This is a series of videos in a classroom type format. This is the second level of classes to describe Social Security from the ground up, to help inform people that are applying and help people that haven't ever gone through it to understand how difficult it is. I'll have another video that will address a particular person that talks on TV a lot about Social Security. For Social Security disability process, there's an application, reconsideration, hearings, and then there's an appeals council, the fourth step. There was some movement, this is 2014 right now, there was some movement to adjust this or make it less available. There was some validity to that because the appeals council as a whole needs to be revamped, entirely revamped. It has some goodness about it. They find errors, but on a whole, it's not set up to be adroit at accepting appeals. It doesn't do it online as of now, and it takes a year for someone to look at the case for an hour and a half. That's unacceptable by any stretch of the imagination, and in no way in any court in the U.S. would they allow this sort of process with someone that's really sick, some of them homeless, to have them wait around to see if even they'll review a case. I'll get into more of that in a moment. So in this case, I've had two different clients I discussed before, John or Jane, but they go through an application, reconsideration, a hearing. Let's say all the evidence was updated, all the right specialists were met, we got input from the specialists, and let's say that there was a treating specialist that laid out exactly why full-time work wasn't possible for a client. And let's add one thing. Let's say at the hearing level, for whatever reason, maybe a judge was having a bad day, but the judge didn't seem to believe the client. Credibility is a difficult subject. Trial courts, the analogy is trial courts, juries, and in bench decisions, judges can decide whether witnesses are credible. Okay? Here at a hearing, whether your level of pain or the level of symptoms you have is credible comes down to a judgment call. It's subjective, but the decision has to, a written decision comes from a hearing, it has to explain why you're denied. If a judge just says, you're denied, it would be sent back. That's one thing appeals counsel can do, is find technical errors and send it back. If you had a hearing and you missed it and then they dismissed it, and you, for instance, didn't get a letter that you had a hearing, that would be a violation of due process. The appeals counsel can pick up on those technical issues in perhaps the more reasonable time frame, even 3 to 6 months. But on a whole, if you lose at a hearing, even with all the evidence that you need, and you know work is impossible, it's pretty clear. That's the fundamental question throughout this, that working full-time is impossible, and we're just trying to establish why the Social Security disability that your client paid into should be paid out, and it's not anywhere near what people make for their earnings when they're working. If we need to go to the appeals council, the hearing denial lists out in detail the 60-day appeal process to request review. It can be done in paper, local office, Social Security office. It cannot be done online, and that's what's fascinating about this. So in the 20 years that I've done this, what we see is that the appeals council is a valid step of the hearings. It's a check on hearings to make sure that judges are writing decisions that explain enough of why there was a no for disability. And that's a good check on any authority, is to have an appeal level. Now let's back into the appeals council. If you have a group of judges that are hired for life and they're politically insulated from review, to have an appellate level in any court system is good. If there are some easy errors or more difficult errors at hearings, any sort of trial court analogy here, there's a level looking over their shoulders to make sure that things are fair. Well, what we have with the appeals council, starting out, is that you can request application, reconsideration, and a hearing online. When you get to the appeals council, you're sending in some paper. That is woefully inefficient, and in fact, I would argue it's on purpose. The appeals council is in Falls Church, Virginia, and what you have are attorney analysts looking at a file maybe a year later to see if there are some errors. Okay, a brief can be effective or ineffective at the appeals council. Another thing that has changed since 2011, we used to have a hearing, and if there was a denial, people can refile if their medical problems are worse, and they can start a new claim. They've changed that. So for people that are sick and can't work, and let's say legitimately sick and can't work, if they lose at a hearing for, let's say, lack of evidence or some error, they're forced to decide whether they appeal to the appeals council, which can take a year or more, and I've had some 2 years, or start over. And with the appeals council, you cannot refile under Social Security ruling 11.2p. You can't start a new case until the appeals council case is done. So you could hold or stall a case for 2 years, waiting for someone to look at your file for maybe an hour and a half to see if there are errors, to send it back to a hearing, maybe reverse. If someone's homeless, I have to tell clients, well, the appeals council doesn't catch errors, and when you lay out errors, it doesn't acknowledge them. And when you lay out errors and they don't acknowledge them, there can be even more information that supports the problems. Appeals council doesn't work. We tell people to reapply right away, and some people are approved when they reapply, and that tells you a lot about how Social Security has made it difficult for people. This appeals council level should be at a check on a hearing. It's becoming less so now, because realistically, if someone's problems are getting worse, it's very difficult. In fact, the exceptions are useless to say that I have an appeals council case, but I want to refile. I got in a car accident. I have some new problem. So what we have right now is a choice. If you lose at a hearing and go to appeals council, you're left with deciding, do I appeal to the appeals council, which gets sent back to the same judge, is the best case scenario in a few cases, okay? Or they just don't find any problems. But we're inserting at least a year on average. We're inserting a year out when they can start a new case. All right, so that's wrong. That's just outright wrong. I was at a conference and was speaking with appeals council personnel, and it was within a few months of this new ruling, this 2011 ruling. I actually was asking a question that would have invoked this answer. Well, it won't be a problem with your question with this new ruling, making people have to choose. And they should have brought it up. They didn't. So if you are in a position of authority in the federal side, rescinding Social Security ruling 11.2p would make eminent sense. The appeals council right should be a right for everyone here. We shouldn't have to have homeless people and people that are chronically ill, perhaps even terminally ill at times, waiting for a bad error at the hearing before they can have their rights. Refiling, having a new case, and that's the last thing I'll talk about here, is people's rights. Most law, if you have an issue and you litigate it and you lose, you can appeal, but you can't start a new case. So where the error is in Social Security ruling 11.2p is it's forgetting to acknowledge that refiling is legitimate. A new case can happen. Someone can be older and have new laws apply. It's failing to recognize that Social Security is a dynamic process, and if someone doesn't meet medical standards at one point, they may at a later point, and we as a public have paid into the system to cover us for certain windows of time. And the 11.2p restricting appeals, essentially trying to make people have to choose between an appeal and starting a new case right away, that's wrong, and that should be changed. If you have any other questions about Social Security, please feel free to call our office at the number at the bottom of our screen. Thank you.